Let me now discuss Rule 17 pertaining to dismissal of actions. It speaks of two things. The first part of Rule 17 speaks of a dismissal by the plaintiff of his own action. The second part speaks of a dismissal of the action by the plaintiff upon the court's own initiative or upon a motion. So let's discuss a dismissal by the plaintiff of his own complaint. Under Section 1, the plaintiff may dismiss his complaint by filing a notice of dismissal. He can file this notice of dismissal at any time before service of an answer or a motion for summary judgment. Once he files a notice of dismissal, the court will issue an order that confirms the dismissal. So that dismissal now is without prejudice unless stated otherwise. So it is without prejudice. Section 2 refers to a dismissal by way of a motion to dismiss. This will be the mode of dismissal if an answer or a motion for summary judgment has been filed. This will now require approval of the court. Further, if there is a counterclaim that has been pleaded, then the dismissal is limited to the complaint. The defendant now will be allowed to prosecute his counterclaim in a separate action unless within 15 days from notice of the motion, he will manifest a preference to have his counterclaim resolved in the same action. The dismissal here is without prejudice unless specified. So as you can see, the choice is going to be dictated by the presence or the service of an answer or a motion for summary judgment. Under Section 1, the plaintiff can dismiss his complaint at any time before there is an answer or motion for summary judgment. Then the court will confirm the dismissal. It will issue an order confirming the dismissal. Unless otherwise provided, the dismissal is without prejudice. If the situation now is the plaintiff would still like to dismiss his complaint, but there is already an answer or a motion for summary judgment. Can he still have his complaint dismissed? The answer is yes, but he will now, instead of filing a notice of dismissal, be required to file a motion to dismiss. Which motion to dismiss should now bear the approval of the court? Again, we do a comparison. Under Section 1, there is simply an order confirming the dismissal. Under Section 2, there is need for the approval of the court. And furthermore, if there is already an answer, the dismissal is going to be limited to the complaint, because the defendant will be given a chance to prosecute his counterclaim in a separate action unless within 15 days from notice of the motion, he will manifest a preference to have his counterclaim resolved in the same action. So that's the distinction between Section 1 and Section 2. As to the effect of the dismissal, a dismissal under Section 1 and under Section 2 is without prejudice unless specified otherwise. So when can it be specified otherwise? It can be specified otherwise in a situation where a dismissal with prejudice is really what the plaintiff wants to have. So if that is the case, it may be specified to be a dismissal with prejudice. Or under Section 2, there is a valid opposition on the part of the defendant that will warrant a dismissal with prejudice. Now, can a plaintiff who has once dismissed his action by way of notice of dismissal refile and eventually have the same complaint dismissed by notice of dismissal? The answer to that is yes. However, if he does it a second time, that will now be a dismissal that will operate as an adjudication on the merits, and he will now be barred from refiling his case. That is known as the two dismissal rule. So you have to note the two dismissal rule. How about in a situation where there was already an answer or a motion for summary judgment, dismissal is sought by way of a motion to dismiss, and the action is dismissed without prejudice? Does it mean that the plaintiff can again refile the action? The answer is yes, the plaintiff can refile the action. Can he have it dismissed again? Yes. How can he have it dismissed again? He can have it dismissed by way of notice of dismissal, or depending if there's still no answer or motion for summary judgment, or if there is an answer or a motion for summary judgment, he will have to have it dismissed again by way of a motion to dismiss under Section 2. The question now would be, would it constitute a dismissal with prejudice? I submit that that will also constitute a dismissal with prejudice, because the purpose of the two dismissal rule is to limit the dismissal to only two dismissals. And it assumes that when you have your action dismissed a second time, you really do not have any intention to further pursue your action. So when you do it a second time already, by implication, it is my opinion that the two dismissal rule should likewise apply. Before we move on to a dismissal by the court or upon a motion, I would like you to note that a class suit shall not be dismissed or compromised without the approval of the court. Under Section 3, it says there that the court, motu proprio or upon motion of a defendant, can dismiss the complaint for the following reasons. So first, if for no justifiable reason the plaintiff fails to appear on the date for the presentation of his evidence in chief. Or the second, if for no justifiable reason the plaintiff fails to prosecute his action for an unreasonable length of time. And third, again, if for no justifiable reason the plaintiff fails to comply with the rules or an order of the court. So to repeat, there can be a dismissal by the court upon its own initiative or upon motion of the defendant under Section 3 of Rule 17 if the plaintiff, for no justifiable reason, fails to appear on the date for the presentation of his evidence in chief. That date or dates refer to the date or dates that will be fixed during pretrial and stated in the pretrial order as the time or the dates allocated for the plaintiff to present his evidence to support his cause of action. The second, when he fails to prosecute his action for an unreasonable length of time. This is a situation that is going to be dictated by what the policy of the court is. Some courts have a policy of allowing a longer period to lapse before they will hold or declare a dismissal for failure to prosecute. Some courts have a shorter period. So this will have to be judged by what the policy of the court is insofar as what constitutes an unreasonable length of time. The third is when there is a failure to comply with the rules or an order of the court. A dismissal in this situation shall have the effect of an adjudication on the merits unless otherwise declared by the court. At this point, I'd like to point out a difference. Under sections 1 and 2, the court will simply say dismissed. The same holds true under section 3. The court simply says dismissed. But there is a difference between a statement dismissed under section 1 and section 2 and dismissed under section 3. Dismissed under Section 1 and 2, provided or assuming that the two dismissal rule is not applicable, is a dismissal without prejudice. So the court should state under Section 1 and 2 whether it is with or without prejudice. Now, if it simply says dismiss, that is without. If it is with, it will state it is with prejudice. Under Section 3, the court simply says it is dismissed. Under Section 3, a dismissal, where it simply says dismissed, is with prejudice. And if it is the intent to be a dismissal without prejudice, it should clearly be stated to be without prejudice. This distinction is material when we need to take into consideration the application of the rule on res judicata. So a dismissal by virtue of a notice of dismissal or a motion to dismiss is something or will not lead to the application of the rule on res judicata unless the court states otherwise, or you have the application of the two dismissal rule. Under Section 3, when the court says dismissed, that means now that it is with prejudice and the rule on res judicata will be applicable. I hope that is clear. We now go to Section 4 of the rule. Section 4 says that the rule also applies to a dismissal by the defendant of his counterclaim, his cross-claim, or his third-party complaint. Please recognize that insofar as a counterclaim, a cross-claim, and a third-party complaint, the defendant is a plaintiff. That is why the rule likewise applies. Now, it says there that a voluntary dismissal by notice under Section 1 of the rule shall be made by the defendant before a responsive pleading or a motion for summary judgment is filed. And furthermore, it says, if none before introduction of evidence at the trial or hearing. Now, what is being referred to? If we analyze, the counterclaim should be a permissive counterclaim. It should not be a compulsory counterclaim because a compulsory counterclaim is not required to be responded to. So a permissive counterclaim together with a cross-claim must be responded to within 20 days, as we discussed in Rule 11, 20 days after service. And a third-party complaint, 30 days after service. So, what is being referred to? a permissive counterclaim, a cross-claim, and a third-party complaint, where the defendant is the plaintiff. So he can voluntarily dismiss it in the same manner as in the same manner as an original complaint, and that is by way of a notice of dismissal. What is confusing is the second phrase that appears in the rule, that if none before introduction of evidence at the trial or hearing. If you take a look at Section 5 of Rule 30, the introduction of evidence on a counterclaim, a cross-claim, or a third-party complaint only happens after the plaintiff has introduced his evidence. Furthermore, if we analyze it further, the introduction of evidence by the plaintiff at trial or at a hearing requires that there should already be an answer. And it requires also that there was a pre-trial subsequent to the filing of an answer, and we are now at the point where the parties are going to present their respective evidences. So what exactly is being referred to by the phrase "if none" before introduction of evidence at the hearing or at the trial? The way it looks to me is that it refers to, and it can only refer to, a compulsory counterclaim. It can only refer to a compulsory counterclaim. Because there are responsive pleadings required for a permissive counterclaim, a cross-claim, and a third-party complaint. If no responsive pleadings are filed, we would not get to the point where there is going to be a trial or a hearing. Because what should have happened when no responsive pleadings were filed in relation to a permissive counterclaim, cross-claim, or a third-party complaint is that the defendant, who is a plaintiff, should have filed a motion to declare the defendant in the cross-claim, the compulsory counterclaim, the permissive counterclaim, and the third-party complaint in default. So, the only other complaint or claim that may be dismissed by notice would then be a compulsory counterclaim. I hope that is clear.